Sorry about this. This is a tad annoying, and I just clicked it about a minute too early, and it's fluffed the whole thing up. So really, really, really quickly, let's do this. It's going to go like this. Okay. A couple of things to note. The statute I mentioned before was Section 87 of the Powers of Attorney Act. That just means that it's automatically presumed in that particular circumstance. You don't have to look at special categories. If you have a power of attorney over someone, by default, you have every transaction you have with them will be tainted by undue influence. That's just the default rule for that. Okay, that's just the way that statute operates. But in the Australian consumer law, we have a bunch of other little sections which say that in certain circumstances you can use the statutory remedies of the ACL where unconscionable conduct or undue influence actually applies. And, as I mentioned earlier, unconscionable conduct is the superset, and undue influence becomes the subset. So in other words, if you've managed to prove that something is undue influence, you get to fall under Section 22 of the Australian consumer law. So, first one's this one. It's still got the same element of trade and commerce. And occasionally you will see in statutes the phrase, the unwritten law. What's the unwritten law? It's the rules of common law and in this case equity as well. All of the judge-made law is referred to as the unwritten law because it stays inside judges' heads. I know, confusing as. All of these rules, which literally have to be written down, is called the unwritten law. That is a technical term to describe the common law. You'll see it in statutes from time to time. In fact, it even has the word as changed from time to time. Okay, what that means is that we are not disturbing any of the rules of common law and equity in relation to this area. If you can prove, using the rules from Amadio's case, that unconscionable conduct exists and it hasn't been rebutted, you can get a remedy in the Australian consumer law, provided that person is in trade and commerce. Okay, so it just lets you use all of the remedies in the ACL, but the cause of action is essentially the common law one. It's just very, very gently plopping over the top of the rules of common law and equity and saying, yep, if you succeed in those, you can also ask the court to do a whole bunch of stuff that you can't get in equity. Remember the rules that I had last week? You can gives the court the power to make them apologise. I mean, you don't get that in common law. You don't get that at all. Yep. Common law. Occasionally, when Parliament does not want to interfere with judge-made law at all, they will use the phrase, this particular rule or this particular part is just the same as the common law of the state of Queensland and the Commonwealth of Australia. It is just saying all of the judge-made law in relation to this unconscionable conduct stays the same. We don't want to touch any of the elements of this cause of action or any of the defences to it. Judges can take care of that. All we are doing here is saying, if you can prove it and the person is in trade or commerce, then you can use the remedies in the Australian consumer law. The remedies in the Australian consumer law and the statute gives courts vastly more power to resolve the situation. So as well as having the ability to undo the contract, it can also do things like do injunctions. It can have damages or compensation orders. It can have punitive orders where they can punish people. They can make them apologize, make them refund, repair, or replace goods. The court is given vast powers under the Australian consumer law. And so all they're saying here is that you can bring an action in the courts using the rules from equity, the rules for unconscionable conduct. I just need to prove that I was under a special disadvantage and you knew about and actively sought to exploit that particular disadvantage, and I signed a contract to you. And the defences, which are, I haven't managed to prove that the transaction was fair, just and reasonable, and that I had independent and third-party legal advice. So you have to prove, assuming that I'm the naughty one. So I'll give you an example. Raz. I've bought a boat off Raz, all right, but I only got that boat because I knew that she was a shopaholic, and I promised to take her shopping and promise is not a very good thing. I brought along all of these magazines, glossy magazines, and she was in this crazy furore about stuff. Got her to sign across this boat. I buy this boat, all right, and then later on she's like, that wasn't very fair. This particular circumstances, you knew about the special advantage I had, you engineered a situation to do it, you actively sought to exploit the special disadvantage that I had. I'd like this contract set aside. You can go to the courts and ask that, all right? And I would have to be the one that would have to prove the transaction was fair and reasonable, and that I encouraged you strongly to seek third-party legal advice, all right? That is the unwritten law. That is the common law and equitable rules in regards to an unconscionable dealing. If I can demonstrate that it was fair, that's fine. The transaction's fine from my perspective. I can keep this contract on foot, assuming I've got a good deal. Now, if this was done in trade and commerce, you're a business, and I did the same thing. I'm not sure how that would work, but assuming we both have ABNs, for example, and it's in trade and commerce, if we go to court and you win, you can ask the court for all of the remedies that the Australian consumer law offers as well. So by default in equity, you just get the right to rescind, undo the contract. I'd have my boat back. Here, we can go and you can ask the court to make me apologise, you can make compensation orders to repair the boat, to pay compensation as well as return the boat, to do a variety of things in regards to that. That's how that part works. Now, not in that part, no. Not in that one. Nope, it's not. You don't need to be a consumer. No, some parts you do need to be a consumer, not that part. Not in that section, no. Consumer guarantees, 55 to 64, those sections, you do have to be a consumer. Here, it's broader scope than that, just they have to be in trade and commerce. Now, again, this part is interesting. This part here, the person is again in trade and commerce, in connection with the supply of goods, or partial acquisition of goods, engages in conduct that in all the circumstances is unconscionable. Now, really annoyingly, this definition is not the same as the common law or equity. It is not the same. It is broader. So basically, they've said, look, you start with the definition from Section 20, the unwritten law, the rules of common law and equity. Here, though, we take it one step further. And the reason we get to take it further is that Parliament has said that it is broader. They literally say this is not limited by situations and circumstances from the common law and equity. All right, the ACL Section 21 has wider application, and it can be in sets and circumstances where I think it might be the next slide. It can be, as well as all of the things you can get in Section 20, all of this stuff as well. It can take into account a wider variety of stuff, and in particular, the first one. So it's got 22 sub 1 sub A. I don't know if you can read that. It says the relative strengths of the bargaining position of the buyer and the seller. Can you do that in equity? No. What's the case? ACCC and Barbados Holdings says you can't take into account inequality of bargaining power. And so, again, Section 20 of the ACL reflects the unwritten law. So to try and take a Section 20 action, inequality of bargaining power is not going to be sufficient, but you can get it under Section 21, etc. If it's in trade and commerce, but specifically to do with the buying and selling of goods. All right, so remember that the set of circumstances that you can use this, that trade and commerce requirement is for both. This one also requires for it to be in relation to the supply or possible supply of goods or services. All right, so what things is that not going to exclude? Things like money lending, contracts of insurance, and most importantly for things with big dollar values, land. Okay, so there's a variety of extra things that the court can look at in relation to a Section 21, so a 21 action. Okay, and let's find it here. All right, and that one's going to be us. This will be the last slide. So when I said that there's a variety of things that you can do, those things are there. So the extra things that you can get if the person happens to be either just in trade and commerce, and you can prove the definition essentially from the common law under Section 20, or they're in trade and commerce and it's for the supply of goods or services. So it's, again, not for land, not for a variety of other things, insurance and money lending and so on. But if it's trade and commerce and for goods or for services, and it falls within the broader definition of unconscionability in Section 21, you can get these. You can get those. And that's fundamentally, that's the main reason why you want to do stuff under the Australian Consumer Law and not just through the, essentially a common law action rocking up to court. Clear as mud? Clear as mud. I thought it would. There's a bit to that to unpack that, eh? The whole point of the Australian Consumer Law, if you can get into it, you get or can get these things. And these things is way more than the courts have power to do at common law or in equity. They just get, courts get a power to do all of this stuff. And other things you can do, go to QCAT. You can do some of these things in terms of disputes for amounts under $25,000. You can go to QCAT and do it. And that's way better than taking a common law action to the magistrate's court. Way, 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 way better. Because it's a significantly cheaper. The courts can go through and look at these things. But fundamentally, they go into QCAT. The law is still the law. If they stuff it up, you still get the right to appeal on issues of law to the QCAT Appeals Division. Okay. You'll notice a similarity, though, between when we were talking about misrepresentation and the equivalent in the Australian Consumer Law, which is misleading and deceptive conduct, duress, and its equivalent in the ACL, which is harassment and coercion, and unconscionable conduct and undue influence, and its equivalent in the Australian Consumer Law is sections 20 and 21. Right, there's a similarity between these things because the statute, ACL, is supposed to kind of take the common law stuff and make it easier. So a person can pick this thing up and read it and go, oh, harassment and coercion, okay, sure, that's what they were doing. We know that it's more complex than that. And in this particular area, particularly section 20, it's certainly more complex because it says unconscionable conduct within the meaning of the unwritten law. How are you supposed to read that if you haven't gone to law school? What does that even mean if you are picking it up and read it? And that's right. That is the trade-off we make. We want to make the ACL accessible for people to read it, but we know that we can't do everything. You can't codify everything. It's too hard. There are so many rules. And we also quite like giving courts in our common law system flexibility to do stuff. And this statutory framework gives them the flexibility to carry on doing things the way they want to. The rule in Yerkin Jones, for example, they might fix that one day. Well, they might not, but at least they have the flexibility to do that. And I'm probably just going to leave it at that and field questions, I think. I'll flick the recording off. Apologies that it got a little bit messy.